All right, thank you, ma'am. Let me just say I'm busy copying all the chat because you guys have done so much great work in that short amount of time. And a lot of what I say, I feel like maybe a little repetitive because you've just suggested some of the things we're going to discuss. So let me go back to my share screen. And if you could bear with me, let me make sure that I get the correct PowerPoint up and where we are. Let me go to slideshow. And again, I welcome any conversation, disagreements, whatever's helpful as we have this transparent conversation. So some of the things I want to talk about that you just talked about were challenges and goals. The Child and Services Family Policy, I don't know if you have a copy of it or not, but certainly you should not be surprised to learn if you didn't know that there is a policy in Montana, and I copied it, and we'll talk about a few specific pieces of that. Barriers, the role of the stakeholders, we're going to do a little bit of a deeper dive into that, and how to raise the bar before you go into your team breakouts. So let's talk about unique challenges, and this is often true in multiple states, but in your area, the distinct judicial regions and culture. And so, you know, I have to remind people, all of us as judges bring our own personality to the bench. And so the way we do things may be the way we learned how to do it, or our preference for the way it's done, or why? Because it's always been done that way. When I first represented, I represented DFACS as a Special Assistant Attorney General for many years here in this state. And I remember I would staff in person with my client to go through the cases and make sure we're prepared. And one day the supervisor said, "Can you send them the questions you're going to ask?" And my gut response was, "No, I've never done that. We don't do it that way." But the reality was I thought about it and said, "That's great. Absolutely, because then they can prepare. They may not know what's on cross, but they'll be prepared to answer all the information." So I think that one of the unique challenges is always, well, because it's always been done that way, I think we have to challenge ourselves. So the goals with concurrent planning is that the law is universally applied. And the second goal is that the practice is improved to achieve permanency in a more timely manner. And it's that practice piece that can be really hard to accomplish. I am stealing the verbiage contingency planning because I have to tell you that's the first time I've heard that suggestion to replace concurrent with contingency. And I think you're right. I think that absolutely describes the goal. And to call it a contingency plan, I think you're right, is different than a concurrent plan in terms of the language. So really appreciate that language to improve practice, right? That's what we want to do. So I want to talk a little bit about a toolkit that was developed. The National Center for Child Welfare Excellence at the Silberman School of Social Work at Hunter College developed this toolkit for concurrent planning. You can use this or not, but it gives you some good points to think about. And some of the things that you all are already doing by an agency, which we'll talk about in a few minutes. But for instance, the differential assessment and the prognostic case review. Full disclosure to all parties in the case planning process. And I'm going to add some of your feedback from the breakout. One of you said early and constant efforts. So it's not just full disclosure, but it's early disclosure, constant disclosure. Next is the family search and engagement. I am working with a state where the diligent searches suffer so greatly that that's part of their PIP. And part of what we've learned is with the turnover, with the volume of cases, with the overwhelmed, and some of the lack of tools that they need to do really effective diligent searches, one of the counties has employed a diligent search worker. That's all that person does are the ongoing diligent searches for every case. And the benefit is they do that all day, every day, and they've really made a difference for that particular region in terms of what they've been able to find out about family. Because like we discussed, and some of you said on after your breakout groups, parents aren't always going to be willing to disclose. They're not going to want to disclose. If they have mental health issues or substance abuse issues, they may not remember to disclose. They may not be able to disclose. So there are a lot of issues and problems around that. So that diligent search piece is really important. And it's a family search, an engagement of the entire family, because you may reach out to grandmother and grandmother may know 6 other relatives. The other thing that I find time and time again, I'm not suggesting you all do it, but it is a huge problem here in my state, and that is nobody asks the kids. I had a kid come to court and say, "What about Aunt, whoever it was, Aunt Betty?" And I said, "Who's Aunt Betty?" And he goes, Oh, it's my mom's best friend, and she used to take care of us, and I always FaceTime her and blah, blah, blah. And I'm like, wow. All right, is this someone you've ever stayed with? Yeah. Are you comfortable staying with her? Yes. Do you want us to look into her? Yes. And everybody in the courtroom, and the mom was MIA because she had substance abuse issues. She kind of fell off the radar. Nobody could find her. And everybody's like, here's been this person we haven't even known about. And all you have to do sometimes is ask the youth, ask the child, not, can you tell us names of relatives, but rather, hey, are there any adults that are safe for you, that you talk to, that you text with, that you visit? So you can mention that and see what the youth come up with. Very important thing to do. Let me just look at chat and take a pause to see if there are any. Well, that means I can get my chat to work. Here we go. Give me just a moment. Always ask the kids, great resources. Yes, absolutely. The other thing I'm going to make sure is that someone is catching all of the chat, because your breakout groups have some fantastic content that I'd love to borrow. With full disclosure, it's from your state. I don't know, Julie, if you guys can capture that, or maybe Marty. In any event, just wanted to mention that it's a lot there. Family group conferencing, we've talked about. Visitation between the family and the child or the youth. Not just visitation between the parents and the youth or the child, but between all the other family members. And yes, I know it can be burdensome. Yes, I can know it can be difficult, because you may all of a sudden say, oh my God, there are 12 people in this little room that fits 6, and they all want to visit with the children, and they're loud, and their family communicates by yelling, because that's how they communicate. So there's all this yelling going on. It doesn't mean that there's anything wrong with the visitation. It just means you have to be able to think ahead and facilitate that. Another toolkit, setting clear timelines for permanency decisions. I find in court, I have to say every time, all right, we're 2 months in. Dad, have you done ABC? Have we talked about that? Why haven't you done it? And do you know, a lot of times the answer is, well, I've been trying to reach that person back and I haven't been able to reach them. Sometimes I've been known to pick up the phone on the bench and say, okay, hi, this is Judge Willcott. I just wanted to find out, this father's saying he hasn't been able to reach you to set up services. What's the best way? And can we set it up now and prevent those delays? Because we need really clear timelines. Transparent, written, and I'm not about blaming. I don't care. If it's an overall issue with the service provider, of course we care. But otherwise, I don't really care what the hang up is. We need to fix it and make sure these services and things happen. Transparent written agreements and documentation. Clear. I met with the parents and had a conversation with them about a contingency plan. What happens if their children don't go back with them? What have they thought about in the past? I was having some conversation offline, and I wanted to share this thought because it was a way those conversations can be had. You can talk about it in a non-threatening way with the family, with the parents. And you can say something like, and I'm stealing this language, who are the support people in your life that you would choose to help your kids if something happened to you? I know I have mine. I know I'm the youngest of 4 siblings, and I know which ones I've said, hey, can you get here first? Not in a bad way, but these are the people I would choose to raise my children if there's an emergency. Now, some parents may not have support, right? Some of these parents are young, may have run away from their family because of their drug use or mental health issues. Regrettably, families disown them. I hate seeing it. I see it way too often. It infuriates me. But their parents want nothing to do with them because of their issues. So they may not have anybody. But then I think it's important to really identify support groups, mentoring groups. And again, I'm stealing some of this content from Julie Burke. I'm going to call you out. But the Urban Indian Center might be able to offer peer support, right? And so it's important if the parents really don't have any support. You still have to set clear timelines, but you also still have to see what can you help provide that family. The other thing is foster parents. I know some foster parents want to communicate with the parent, some don't, but they always should be supporting your goal of reunification as a foster family, even if they're foster to adopt. So maybe that relationship is something that can be built. I've seen some super successful cases when the foster to adopt and the parents start working together from the very beginning. And foster parents will do everything to help transport, to help the contact, to help all of those pieces for the parent, to help support the parent. And then if it doesn't work, I've seen those foster families adopt so the parent still has some involvement, right? Even though rights have been terminated, because we all know children eventually may want to find out who their parents are. Committed collaboration between child welfare, the court, service providers, that's already happening here. Montana's ahead of the game compared to other states, but service providers, that's a missing piece. Are your service providers aware of, familiar with concurrent planning? They may need to have a similar conversation so they understand the goal, the purpose, so that they can support these early on conversations. Okay, what's your contingency plan? This is a great substance abuse recovery program, but you have a relapse. And if you have a relapse, what's your contingency plan? What are you going to do with your children? Because I'm here to say, if the parents have a good contingency plan for what's going to happen if they relapse, you may be able to prevent the children from even coming into care a second or third time. Specific recruitment, training, and retention of dual licensed resource families. This is in the toolkit, but I remember some conversations with your division there and knowing that you all do have that, so I'm not going to really focus on that. What is concurrent planning? If the child welfare agency determines that the safety risk posed by the family remains high and the prognosis for reunification is poor, then a concurrent goal for permanency must be considered and evaluated to determine appropriateness. Again, this is from the Children's Bureau. This is their language of policy, right? This isn't in the law. This is their language of policy. Because the key to concurrent planning, and you all said it after your breakout groups, and one of you said it in the chat, is early assessment. Early assessment, early assessment. I can't say it often enough. If you get them working together with you to assess and determine who else might be appropriate and what a backup plan is, and implement that plan, you can prevent some of those delays that were mentioned as a barrier. Let me just say this, all over the nation, the amount of time that has to wait before there's kinship or financial assistance for guardianship, right? Regardless of what it's called in your state, there are federal requirements that can create a delay. And so you're right, maybe the child has to be placed there for 6 months before they're eligible for kinship or kin gap or whatever it is your state calls that financial resource. Okay, so if you start at the very beginning to identify these relatives, to work hand in hand with the parents and the relative and get placement there, then 6 months, 12 months down the road where everybody was really optimistic that these parents can do their case plan goals, right? They just needed some help and you've got great service providers in and the wheels come off and they can't do it no matter how much support you take in, because we're all going to see those cases. It doesn't matter how much support they have, they're not going to succeed. Regrettably, that's part of human nature, child welfare, it happens. So in those cases, the sooner the children are with relatives, the sooner those eligibility requirements are met. So it's really a key component. Poor prognosis factors have been identified by several states. I just wanted you to know that. This is one that I took from, again, the Children's Bureau. Now, I want to talk, make sure I didn't skip a page. I didn't. I want to talk about some of the policy 4023, and according to my research, this was the most current policy, and I hope that I'm not wrong, but I trust we have agency representatives here. Marty, Nikki, you'll speak up if any of this has been changed. But let's talk a little bit about and this is the Child and Family Services Policy Manual. Concurrent planning. A case plan that includes the development and implementation of 2 or more plans. We've talked about that ad nauseum in the shortest possible period of time through reunification, adoption, guardianship, or APLA. Plan A, intended to safely reunify the birth parents with their children. And then you talk about Plan B, the permanency for the child through the other means, whether it's adoption, guardianship, other planned living arrangement, right? So that's in the policy for the agency. Also, and this is something really important, not just for the policy, but for all of us as stakeholders, not surprisingly, a concurrent placement does not occur by default. If we are not actively working them all as the stakeholders involved in this triangle to improve our practice and increase permanency outcomes, and let me tell you, let's talk about the reality. If if the state, any state, is unable to meet the PIP goals and requirements and improve permanency, for instance, through more effective use of concurrent planning or more timely filing of TPRs, whatever your PIP goals are, you all know if you don't have substantial conformity, you're going to be fined and you're going to lose a lot of money. This state has paid a lot of millions of dollars because of failure to do that in the past. Hopefully we're on the right path. So my point is, you have to keep in mind, concurrent's not going to happen by default. My will's not going to get done by default, right? You've got to take the active steps. Everybody, not just one agency stakeholder, but everybody. Also in your state agency policy manual, concurrent planning requires, and this is part that one of you mentioned, and I was copying it because you had great information, but that it requires the child protection specialist or designee to identify and work toward developing an alternative permanent plan for the child. At the same time, the child protection specialist and parents are working towards the child's return. Now, I have worked with states where those are two different people because they have the CPS worker and then they working with reunification, and then they also have a foster care worker or adoptive worker who's working on all of the other aspects, the diligent search. Every county, every state, every district, every office does it a little differently. But the important thing to note is that the policy and the practice should be, and judges, I encourage you to have these conversations in open court. Don't blame, I'm not saying you would, but it's easy to with the systemic issues we see with child welfare agencies. But have a conversation about, okay, tell us, is the division working towards reunification? Who is the child protection specialist or the case manager or the worker who's doing that? All right, so who is the person that's working towards another permanent plan? What is that plan? And who is that person? Now, judges, having that conversation doesn't mean that you have to say, this is the court-ordered concurrent plan. Because the distinction I want to make is concurrent planning, ING, versus concurrent plan. You determine as the court when it's appropriate to order a concurrent plan. None of this takes away from that. However, I would suggest for it to be effective, concurrent planning, ING, has to happen from the beginning of the case. And this is where it starts. So in open court, in the pre-planning, have open discussions about this. Nobody's being blamed. We just want to know who are the people working on each of these. What's the alternative being worked on? What efforts have been made for the diligent search? Have you asked this person? Have you asked that person? You need to have those conversations very early on. Next, just as the policy manual, again, sets out the steps of concurrent planning, process, and placement. So step one, the child protection specialist conducts a diligent search. And note what it includes, the absent parent and other relatives. What a great policy manual that says the absent parent, because time and time again, we see a parent left out, typically the father, right? Often, if there's a punitive father, if anybody else says punitive father to me in court, it makes me just want to scream. It's punitive, but people say punitive, meaning they don't even give that much thought to the fathers. A lot of times in cases I see, I'm in a metro city, maybe, hopefully it's different if you're in more rural, but I doubt it. I had twins and the mother didn't know who the father was. No judging, okay, but let's try to sort it out. Well, I had sex with these 3 different people. Okay, let's do all the DNA tests. They come back to court and I almost fell out of my chair when they said, well, each child has a different father. I didn't even know that was possible. But the sex had been had within a short enough time frame. Each of those children had a different father. So it's really important to look at that absent parent, and that's included in the policy. Step 2, immediately upon placement, they must discuss concurrent planning with the parents and family. Immediately upon placement, or as soon thereafter as possible, but it needs to happen immediately. It's that early and constant communication that one of you referenced after your breakout session. What is concurrent planning? There should be full disclosure to all participants in the case planning process. Yes, it's a hard conversation to have, but for the sake of children, it has to be had by everyone. The agency should engage the parties in the development of the concurrent goal during the case plan meeting, early constant case plan meeting. Now, you may have parents storm out. You may have a primary caretaker that leaves the office building and says, I don't always have great language. I try to clean it up, but jump off because we don't want to have a conversation about adoption or relatives having custody because this is our child. Yes, they may be angry. Yes, they may react, especially if they have substance abuse, mental health issues, their behaviors and trauma. Their behaviors may be difficult to deal with, but it doesn't excuse not having that conversation early on. Always have somebody there to witness. Don't be alone. And to say it in a way that's like, listen, everybody has to have a backup plan, a contingency plan. What's your backup plan for your, God forbid something happens to you during these 6 months that we're working on your plan? There's got to be someone, maybe there's not, so not a good way to say it. I take that back. Is there someone? Is there anyone? Maybe it's somebody that used to babysit them or watch them as a kid that they're still in touch with. You never know what a deep dive might find. Important to identify extended family as soon as possible, attempt to engage the family. Now, this can be done during a child and family team meeting. I need to suggest mediation. And I don't know, I've had this conversation with some of you all, but I don't know the extent to which you all utilize mediation. However, mediation is an amazing tool to get everybody to the table and have their voice heard. And I often see results of mediation. They may not reach an agreement, right? But often they can have a partial mediated agreement where they agree, here are 10 more people that we want you to look at. Or, I didn't want this relative to be considered, but after mediation and going back and forth and sorting it out, I'm willing now to have them considered. Why? Because people want to be heard. And mediation is an opportunity for a parent's voice to be heard, for relatives to engage and be heard, and try to overcome what might be 100 years of dysfunction. All of us have dysfunction in our families, but you may be able to mediate a conversation to get better outcomes. Concurrent planning is an opportunity to partner with the families, engage them in planning for the children. So we kind of need to flip the script and realize that if you call it contingency planning, everybody needs to be involved in that. It's no good if I say, okay, God forbid something happened to my husband and I, my children are going to my sister. If I haven't had a conversation with my sister to say, hey, by the way, are you ready for 3 teens? Gosh forbid something happens. So it's that whole family engagement. Think of it outside of the realm of child welfare and try to get them to think of it outside of that realm. Of course, it's a part of it, but try to take a step back, pull it out and say, this is what we're doing with this piece to try to have a plan for these children. Let me stop there and see, are there any, whoops. There we go. But before we go on, any chat, I haven't looked at it lately. Let me just pull up chat and see if there is anything. Well, of course, it's not going to my chat. I don't think there is because it's not saying there are more messages. And it may just be there. All right. I'm going to look for any alerts in the chat or anybody can just speak up. That's the definition of concurrent planning. Let's talk now about some barriers. And these, some of you discussed after your breakout room in those notes, but high caseloads, staff turnover, again, systemic issues, a lack of time, and that comes into play with diligent searches nationwide. Diligent search, #1 reason nationwide statistically that diligent searches aren't done or done well or completely and are almost never done ongoing consistently, lack of time. Courts not understanding concurrent planning. I would challenge you judges to one day in an open court, just say when you've got one case with all the players in the room, how many of you know what concurrent planning is? I'm sure all the hands will go up. All right, just give me a definition. And I'm going to bet you at least one person says it in a way that doesn't seem to make sense to you as a court. Or in the alternative, there's someone going, oh, wow, that's concurrent planning. Again, it's not because people aren't smart, don't get child welfare. It's because it's not always discussed. CASAs, guardian ad litem, they need to have the same conversation to understand what it is and the importance of it. And I have had CASAs in my courtroom, and I love our CASA program, and I utilize our CASAs, and I rely on our CASAs, but I have had some put in their report, the only goal to ever be discussed should be reunification. This parent is very defensive. And if you discuss anything other than reunification, this parent will fail. I've had it said to me that directly. And so we've had to have an at the bench and then an open conversation about, I understand that. And maybe there's a therapist or a parent aide who can help with the defensiveness and the trauma and reasons for that, defensiveness. But it can't just be reunification because there's very poor prognosis. 6 of her kids have been in care. This is child number 7. Unfortunately, there's statistically a poor prognosis for this child to go home. So we've got to talk about an alternative plan. Private providers of family services, I've already touched on that. Many don't even know what concurrent planning is. It's a legal concurrent. Who says concurrent, right? Outside of our world and the legal, who says concurrent? Oh, let's go talk about a concurrent plan, honey, because we need to talk about the kids' education. No, we never use that word. Lack of placement resources, always an issue, every state around the nation. Lack of meaningful parent-child visitation, again, especially an issue following the pandemic and even in the pandemic still, because that's moved to virtual, which is a great tool. It's a great resource. It's not a great substitute. Because guess what? I don't want to see my kids on screen all the time. I want to hug them. I want to see them. I want to hear them. I want to watch them. You can't do all of that virtually. Lack of quality assessment of resource families, right? And that goes to some of the delays mentioned as a barrier in assessing a potential family. ICPC is a problem. I don't know if you have border agreements in Montana, but I want to throw this out for CIP and everyone else to kind of have in the back of their mind. If you are seeing a specific state has a lot of ICPC because they're moving back and forth across the border, you can always try to talk from the head ICPC to the head ICPC to do what's called a border agreement, so that perhaps there's some shortcuts that are still not changing the requirements of ICPC, but rather making it a shorter time frame to complete ICPC. We've done that effectively with Florida because so many of our residents of Georgia and Florida go back and forth, and we don't want that huge time delay. So yes, ICPC is a bureaucracy. It's going to take time. However, there may be ways to effectively shorten that. Insufficient time for case managers to support resource parents. I don't know of any case manager anywhere in the nation that has excess time. They just don't. And you can't expect them to work 70-hour weeks. When I represented the state agency, there was one judge in particular. Nothing ever was an acceptable reason why the department had not done something. He did not care what the volume of caseload was. He did not care what the personal responsibilities of that person were. He did not care if it meant that the case manager had to go out at 2 a.m. 5 days in a row. Because his perspective was, it's not about that individual, it's an agency, and they are responsible for doing every single thing. And he was known for that. So we knew if we were going to court and something hadn't been done, we better fall on the sword. And I'd have a pretrial to do that and say, listen, this is why it's not done. You can yell, you can scream, you can make a no reasonable efforts finding, and then we lose money. But the reality is it's not done, and here's why. Well, somehow you've got to find time for your case managers to support resource parents. Some states have found that dividing up the workload differently amongst the specific region or district might help a decision for you all, but that's just something to think about. Roles of the stakeholders, let's move on to that piece. And here's why I want to move on to this piece, because again, it's a triangle. The stakeholders have the same amount of responsibility in concurrent planning than the agency. Let me say that again. The stakeholders have the same amount of responsibility in concurrent planning and case plans than the agency. And here's how I mean that. Agency attorneys, they can assist the agency in identifying and analyzing prognosis indicators. They can assist the agency in analyzing any barriers to permanency plans. If there's an ICPC holdup, okay, it's true. The local goes to the state, goes to the state, goes to the local in terms of that ICPC work, right? Everywhere across the nation. But your attorney can always get involved if there's been a holdup and you can't get an answer or response. Because the attorneys may be able to talk to the attorneys in the state, and it may be something inadvertent or not appropriate, but you have to try to figure out what that is. Agency attorneys can help do that. They can assist the agency in taking actions to identify relatives. I have a personal PI, a private investigator, that we use through the Cold Case Project, and those are children languishing in care. And that private investigator is available to cases identified as likely to age out of care when they want to go back and try to find relatives that could never be found. They've also successfully found parents whose rights were terminated years ago when they lacked the protective capacity, who are now clean, remarried in 2 situations, clean from substances, remarried, successfully raising new children, additional children. And now it turns out they want to be reunited with the child in care who's been there for 7 years. So we look at reinstatement of parental rights. You have to, your attorneys can help you do that, I would suggest. Parent attorneys, they have to encourage the parent to identify relatives. They have to counsel them to do that because of the diligent search and the reality of we'd much rather have a first placement with a child be a relative, even if reunification is going to occur in 3 to 6 months. Parent attorneys should be encouraging the parent to participate in concurrent planning. Parent attorneys need education all over the nation to realize it's not saying you're not fighting zealously for your client for reunification to occur, but rather contingency plan. Child attorneys, court-appointed special advocates can provide the agency with names of relatives identified by the child because they have a good relationship typically with the players because they're putting more time into the case as a volunteer than some might be able to, and to advocate for appropriate concurrent planning to reduce delays and permanency. Again, all of this is education of stakeholders. The roles of the stakeholders, we want to talk now about you, the judges. You play a very important role. I think that's been made clear. To introduce the subject to concurrent planning at the very first hearing. It gives courts, excuse me, I'm just adjusting my chair. It gives courts the primary responsibility for ensuring that the agencies implement concurrent planning within the ASPA timeframes. The court's responsible for that oversight. Let's raise the bar. Judges should inquire about relatives. They should remind the parents it's ongoing when they think of someone or if they get back in touch with someone to let everyone know. Keep in mind with social media, I'll tell you what, these kids and youth, they know of 18 relatives that they keep in touch with on a daily basis because of TikTok, Facebook, Snapchat, texting, all of those things. All the family is much more in touch now or has the ability to be than ever before. Judges should encourage parents to engage in the planning for their children and approach it that way. Parent, we're not saying anything about you or your ability to work this case plan. We are saying for your children, what's best for them right now while we're getting there? What's the best plan for them? And make sure the agency is considering concurrent. I've given you the policy, you know what your law says. Talk to them at the very first hearing about all of this. More transparency means more effective concurrent planning. That's the whole goal. So concurrent planning, just a visual aid. Some people like to see that. Engaging the parents to identify relatives, to engage the relatives, to assess reunification, to consider the appropriateness of other permanency plans. Again, I like your verbiage, contingency plan. I also like the one who said we need to do this early and consistently on a constant basis. All right, I talked fast. And so let's ask now, I'm going to try to pull up my chat, but also I would welcome questions or conversation based on those materials as food for thought. And I was really quick. Oops, I went back to the wrong one. Let's go back there. The other thing, in addition to mediation, I wanted to mention settlement conferences, pretrial conferences. Those are great tools for having all these conversations, maybe with all the parties, without the attorney, the parents listening or the parties listening. Because a lot of times during settlement conferences or pretrial conferences, you can flush out a lot of the family dynamic and who the relatives are and what the parents want to figure out the best way to present it to the family to get their engagement. I wanted to mention that as well. All right, I don't see any questions or chats. I know that was quick, so I stand ready to serve, but I'm going to turn it back over to you.
So one of the comments that we had, and I'm just myself interested in it, Judge Fair, you made a comment about provisional approval of licensing guardians. And so I'm not terribly familiar with that. And I'm wondering what it is so that maybe others would be interested in that as well. If she's still here. Anyone on Judge Fair's team that knows what she was talking about there?
I'll pass the buck to Bonnie or Jason. They were involved in the discussion.
Sorry, that was my fault. I had to answer a phone call quickly.
So you made a comment about, and one of the barriers being, the people were commenting on the licensing, and the licensing was taking a long time. And so you said something about you're concentrating something on provisional approval of licensing of guardians. And of course, we've had lots of presentations on, increasing guardians, that is maybe a great alternative, could be a win-win at times. And so what is the provisional licensing of guardians? That's new since I was in your job.
So we probably should let Jason explain it. I got lucky. I had Jason Larson, our regional, in my group. But what it does is it allows for the funding to start. So it's Jason and someone else within the department have to give kind of a first glance. Yes, they most likely are going to be approved for licensure. And so then the funding can start. And so Bonnie Rothy had given an example where, you have a case where placement, nobody has an issue with placement does this provisional, the funding starts, but then we still have to go through the full licensing process, and none of that time then where they're receiving funds as a provisionally licensed placement counts towards the 6 months for the guardianship once they're officially licensed. And so it just creates this extension, which can be really unnatural and just prolongs resolution of the case. And so if there's a way to, not to say that we don't have to go through the full licensing process, but to say that the provisional time where they can receive funding can then count towards their 6 month requirement before we can do the guardianship. The other piece of that was having the conversation at show cause and then following up at adjudication. So you're only, 35, 40 days into the case, and say, all right, have we started the process, if appropriate, in getting licensing started? Because I hate it when you get to the 6 month, you're at TLC or extension time, and we haven't started the process yet. And so my concern to Jason was then, is that going to create more of a backlog than we already have with licensing, especially with the subsidy approval that's done by Mark out of Helena? And he seemed to think that they're very busy, but that if we don't abuse it, that certainly we can be more aggressive about requesting that process to start. So now that I've said all that, Jason, do you want to correct everything that I said that was inaccurate?
No, I don't think, I know that was part of our discussion, and I think it's just been something that we've talked about as a state. I think we've gotten better and improved that. It's just that we have to wait that period of time, which I know causes issues sometimes, because then we get questions in the specific district courts.
There was a bunch of chats as well about mediations. And I know when we started doing some of these when I was at the district court, and unfortunately there isn't really, we haven't been able to find the budget, right, to hire mediators. Various jurisdictions have kind of on, I would say on pilot basis, or at least to get some of those processes going. At times we have used pre-hearing conference facilitators, but over time CIP does not have the funds that available to us, although we wish we did, that we could just have mediators. But we have tapped into, in various jurisdictions, we have talked to attorneys who do, as part of their pro bono work, right? to conduct mediations. And we have had DN attorneys like, I'm happy to mediate your case if you will help mediate my case, as sort of a solution. And as in Yellowstone County, I know judges are helping to mediate cases that are not theirs. And so, I mean, maybe some creative discussion of how to get mediations going. And then secondarily, you know, can we figure out how to pay for them? I mean, the legislature, for instance, this last go round has, you know, wanted to make lots of changes in the abuse and neglect work in our statutes. And one of the discussions that we continuously had is that would be great, but we're going to need some resources to do this. And one of their goals, of course, is to improve our outcomes and reduce, you know, time that kids are in care, improve reunification rates, et cetera. And so, I mean, that may be one of the things that as we move over the next 2 years, planning for the next legislative session, you know, if they're serious about that work, that's an area that we need some help with. So be curious of people's thoughts there. Other comments, things like that before we do break into our next group discussions?
Justice Gustafson, I saw a question from Cindy Bassnett. Maybe it's to Judge Willcott. It says, I'm wondering about the conversation happening at the permanent plan hearing. It seems like a checkbox to tick off for federal funding.
And I just responded to that in the chat box, but you may have a, no, you may have a better answer, Judge Gustafson. And here would be my response. That is the perfect time to always have the discussion of ongoing diligent search. What is the status of the ongoing diligent search? What's the prognosis of the reunification plan? And to do a deep dive into not just what's the status of the diligent search, we updated it yesterday. All right, how did you update? Who did you talk to? Did you talk to the child and youth? I think that's the entire, not entire, that's a big purpose of permanency hearings. I also wanted to mention one other thing, and I may have been confused. Were one of you saying in the chat that there is a state that will not allow you to do an ICPC request if reunification is the plan? Did I misread that, I hope?
No, you didn't misread that. We have run into that. We have run into all sorts of what I would term goofy things at times, like we won't reunify with a parent, a non-offending parent, unless they have a treatment plan. We've had that issue come up. We've had a number of these kind of things creep up into ICPC issues. So any suggestions you have in that regard would be welcome.
So that one's just unique. We too, of course, have all of these things that come in and a state saying, nope, we're not going to do that, even though from our perspective, it's the right thing to do. So the one I've never heard before is, oh, it's a reunification plan, we're not going to do ICPC. So my best suggestion, I am more than happy offline. I'm going to give you my contact information. I'm going to put it, I'll leave this up and then do it. Anybody's welcome to reach out to me, not because I have the magic answers, but because we have a lot of work dealing with other ICPC offices and ways to sometimes get to different people to have conversations around how can we overcome that, because that's not helpful. So happy to at least provide that if that's helpful to you all.
Any other, that raise anything for anyone that want to discuss before we break into our groups? We're a little ahead of schedule, but that's always nice, right?
So the only thing I would add is just within that ICPC piece is I think it's sometimes even language being used that if we're looking to do an adoptive license, like we've learned a lot, depending on the state, it's very important that you know, are you requesting a foster care license, a kinship approval, or an adoptive license? And if we're looking for an adoptive placement, that many states won't accept doing an adoptive home study unless we have termination of parental rights. So there's some of those issues, I think, when we talk about, you know, reunification, we consider we're still working reunification until we have TPR. And so sometimes that can be a rub. But any support around ICPC, improving the ICPC process would be greatly appreciated.
Excellent. And so look, we also on the chat have a very gracious offer by Judge Fair that she's happy to do some DN mediations on sticky wicket issues via Zoom. So if you have something like that come up and you want to start trying some of this stuff, maybe that would be a great place to go. So look, somebody else, and so is Judge Harada. So excellent, some resources. We are going to take a, go into our groups, I guess, and our breakout discussions and really discuss some of the things we've been talking about. We really would like you to identify, what are steps that you individually, like each one of you could take in your practice to start using, we'll call it contingency planning in DN cases. And how can you help make the process more effective? How do you think we can have these concurrent or contingency plannings be effectively raised and addressed at a number of stages? One, at the pre-hearing conference. How do you think the best way to address that is and get the discussion going? How would we have contingency planning effectively addressed at status hearings and then at permanency hearings? Because all of those occur sort of at different stages in the process. And so I think maybe some discussion of, a plan for how we can start doing that in our pre-hearing conferences, in our status hearings, in our permanency hearings. What is each person's role and how are you going to positively contribute to this to make contingency planning something that we are doing as part and parcel of our DN case processing over time? So I guess Kevin's going to put us in chat rooms again, maybe get somebody to take some notes and so that you can at least give us a highlight of your discussion after we come back together.
Are we doing 20 minutes again?
Let's do 25.
Okay.
I think my group was the last one to return to the main group. We had a pretty lively discussion going on. I think we have Judge Halligan's group we haven't heard from today. Someone from that maybe can share with us some of their discussion.
Certainly. So Judge Gustafson or Justice Gustafson, I've unfortunately been kind of popping back and forth in with the discussions because today's my law and motion day, but we've had some great discussions, and I would just perhaps ask one of our recorders, either Ms. Harrison or certainly someone else, to just offer some of the reflections that we've had. One of the concerns, I guess, of course, with concurrent planning is our public defenders have been saying, where is it required? Is it required under law, under Montana law, under policy, under federal law? And so that was just kind of our last issue. So it was a concern just because parents often look to the law and it's easier to, I guess, emphasize these conditions if it's a legal requirement. And so I guess I would just allow our group to weigh in about.
And Kelly or anyone else, feel free to chime in, but we talked about mentioning concurrent planning at the beginning.
Kelly, to begin.
Yes, so we talked about mentioning concurrent planning at the pretrial hearing and structuring the meeting in such a way that would be respectful to the families present, because families may not be comfortable with having other family members there when discussing sensitive issues. So perhaps having that at the beginning of the discussion and sort of separating out that intervention conference hearing. Anyone else like to add something? Kelly?
Well, I guess I had just added that, we had talked about the standing masters, bringing that up at the pre-hearing conference, as Ally just stated. But I do feel like that is something parent attorneys can do, and I would prefer to do a conversation myself with my client to prep them for the pre-hearing conference about all the issues that would be discussed at the pre-hearing conference, so that I can, and that's why I was getting into, I kind of do a spiel with my clients about, the 15 out of 22 months, worst case scenario. I can add in the discussion about concurrent or contingency planning in that. Worst case scenario plan A doesn't work out. The department does have to work on a plan B. My question kind of was, I was not thinking of where that was in the law. Because I can tell my clients, you can look at the statute, the department's required to make reasonable efforts at reunification. Reunification is the goal. That helps the clients feel better. But then in discussing concurrent planning, where do I point to that it's in the law, that this is why this is being brought up and this is going to be discussed. So it's not just a really mean CPS worker wanting to place your kids with someone else. It's required. This is why it's required. So basically having those conversations with your clients ahead of time to prepare them for the conversations that are going to occur at a pre-hearing conference or a family engagement meeting or in court. And well, we have seen, we do have some reference to concurrent planning in our statute, so as well as in the policy manual of the department. And I know Nikki put up earlier a website, I think, where we can go to look at kind of what the department's formal stance on that is. Is that correct, Nikki?
Yeah, yes, it is. And then Eleanor put in kind of the Montana statute that talks to it, and Judge Willcott may be able to talk more of the federal part of it also.
I think the discussion of some of the federal, how this comes in, at least as a judge in talking about it, is federal timelines. And so, having to talk to clients about what the federal timelines are and how that kind of fits in with their case may also be helpful, Kelly, in that discussion with parents. Our group, and I'm going to kind of get Maren Hatfield to tell us a little bit. She does facilitates pre-hearing conferences and has kind of a different or an additional perspective of that, at least at a pre-hearing conference for the facilitator to segue into it would be an easy deal. And I guess I'll let Maren talk about that.
Well, I can't speak for everybody's pre-hearings, but I think we probably all use John's notes or some version therein to run through the topics that we want to cover, and the main ones being services that are going to be provided, visitation, and then placement. So I was telling Justice Gustafson, since a third of our conversation is regarding placement, and maybe more than that in ICWA cases, we already have that conversation about where kids are, how everybody feels about that. Even if there's agreement on the placement, we still go into, okay, well, just, if anything were to happen to that placement, is there other people that you want looked into that the workers can already start to have conversations with and just be aware that those people exist? So kind of piggybacking on the whole, who are your support systems, which is also a question that John has in our notes that we should be asking, just like, what are support people do you want included in this? And I was saying I don't do a great job of making sure that we really jump onto that to see not just who could be placement, but who could be support, because those people might also maybe be able to be placement at some point and just aren't at the forefront of the parent's mind if placement's already going well. But because we're talking about placement, we could have that conversation about, okay, well, what if we were talking about long-term? What if something did happen to you? Is this the person that you would want to be that person for your kids? And how do you think that they would feel about that? Would they be willing to be that long-term placement? So because we're already opening that discussion, I think, and it's right at the beginning of the case, I think that that would be a really great opportunity as a neutral person to bring that up so that we're not having clients have that reaction of they're just adopting out my kids now.
Right, and I guess phrasing it in the way, like if something happened to you along the way with, I mean, you like this placement, you know, now, but I mean, is it something that if something happened to you today or tomorrow, would this be the thing, you know, what that you would have put in your will if you had one? I would probably sort of change how you bring it up as opposed to when we terminate you, what do you want to have happen? Little different language there. Judge Rieger's group talked, they posted here on family support teams, and I'm somewhat curious about that. How are being used to do this? Tell us about family support teams and what are they? What are they? And who is using them, and et cetera. This is something I'm not super familiar with.
So this is Tom, the note taker, and Laura had spoke a bit to this, and unfortunately she had to step out. So I don't know if anyone else wants to take a stab at it, but the big part of kind of the takeaway from it was working on potentially getting CASA involved more in those family support team meetings, so that they have some insight into the cases prior to the removal piece coming into play. But Eric, I might play the tag you're at responsibility thing and see if you have more to add to that.
Sure, I could talk a little bit about family support team meetings from the perspective of meetings that we're having in Eastern Montana. So the model that we're using within the Eastern region, so specifically when social workers go out and get a report, they start their assessment. At the point in their assessment, if we establish that there is immediate danger, then the social workers work with the families, the family support team coordinator, service providers to put together a impromptu meeting. Our goal, we don't know that we necessarily always reach this goal, but our goal is actually from the point of identifying immediate danger to actually holding the meeting within 3 days. So the first part of the meeting really is focusing on, is there a way that we can support this family in addressing whatever issues are contributing to children being unsafe while the family remains intact? And so what would that look like? What sort of safety resources would we need? What sort of services would we need? How can we develop a plan, the prevention plan to one, keep the children safe, but also support the parents in addressing what they need to. If the situation is not a situation where the family can remain intact, then it's a discussion. We'll have preliminary discussions around concurrent planning in the context of if the parents can't take care of the children, who else can? And also just identifying some of the initial steps that need to be addressed so that we can really expedite the process of treatment, rehabilitation, and ultimately reunification.
All right. Well, that's kind of interesting. A couple other things in our chats. We talked about this in our group too. Somebody making a Seneca search, and so I asked what that was, and they said, I don't know. We just emailed one of the other social workers who does that work. So maybe one of our department people could explain for our group sort of what is the Seneca search. And there was some discussion as well in our group that at times you get a list of these from this Seneca search, a list of potential family members, and that then the CPS sends out a letter to various people on this list of would you be a placement, et cetera. sometimes the parents are not plussed by that, and there's issues with that. And so I guess, I don't know, Nikki, maybe you can explain kind of the Seneca search and maybe how how are you training or advising folks, to contact these people when parents are against it, or, there's some dispute there?
Sure. So I think the word Seneca search gets used kind of widely. We use a variety of different search engines to do that. Seneca search is a specific one within the child welfare organizations that we've used for years, but we've actually found some other ones that are even a little bit better as far as being able to identify people and give better information. But the thought is obviously that we need to have the parents' names and the child's names and run through this search engine and then come up with the names and addresses. And the intent is then you would take that information to the parent and say, hey, do you recognize these people? Are you aware of any of them? Oftentimes they may be or they may not be. And then we do send, we can either do a call to a family or to a member and just kind of give them the basics of, hey, we have some information that you may be related to this person, see if it's even accurate or not. And then kind of work our way through that. I think we've really worked our process to think about it as connections versus placement. I think we've learned through the years that if you open your statement with, hey, do you want, one, are you related to this child? And two, are you willing to be a placement? It's very kind of off-putting to people, right? They have no idea. They may have not heard from this relative in a while. And so really just trying to talk through connections and interest that way and do a little bit kind of softer approach. And so, the intent really is to figure out how to find more support for the family, but also for the child through that concurrent planning piece. But I don't know if anyone else, any pieces I'm missing with kind of the Seneca search or other search engines that you think would be helpful for this group to know from Child Family Service folks.
So how do you balance out, sort of the privacy of those kind of things, right? I mean, if a parent is really like, yes, that's a relative, but I don't want anybody contacting my relatives. What does the department do to address that? And what do you perceive the legal obligation to go contact those people anyway as, et cetera?
Yeah, I mean, I think it's a lot of what we've been talking about throughout today, right? It's really doing that assessment of the family and where they're at. And are we, pretty sure we're looking at reunification, or is it pretty poor prognosis? And I think the more we've been able to assess and what's the length of time the child's been in foster care. So I think the further we are down that track, the more responsibility the department has to reach out and find a placement and more connections for the youth. I think when we start those conversations, we don't really talk to what, the reasons the child's in care, the parent situation. Obviously, we don't talk about where they're at in their treatment plan. It's really about the youth and what, do they know the youth? Really gaining more information about them as a family, what is their relationship with this youth, and really keep it very youth focused versus the parent side focused. But we do have a responsibility to ensure that, the kids are not just lingering in foster care. So the level of that contact and that information sharing really is a very gradual process and very dependent on kind of where we're at within the case and the prognosis of the parent.
Excellent. So we've also had a little bit of update on our mediation update. It appears that the state organization of mediators, Dr. Hahn, will be contacting them. We may have a lead on how to develop some mediation for us. So that's very exciting. And obviously CIP is very excited about working with Dr. Hahn in that regard, because in the jurisdictions where we are using mediation on a lot of these things, we've seen great ability to resolve all sorts of things in that manner. So I don't know, Dr. Hahn, if you have anything you wanted to add.
I'm willing, I'll reach out to Montana Mediation Association and see if there might not be a special category that they can create for these DN cases. They have a special category for family, the DR cases. And Judge Fair volunteered to help with some sort of a training, maybe that might have CLE status, to bring on some mediators DN attorneys, standing masters, judges, and PHC facilitators will all be quite familiar with what's going on in the DN cases, but other mediators that might be trying to get hours, that sort of thing, might be very receptive to a training. So we could get a pretty good sized pool of volunteer or low cost mediators involved with this. So I'll give it a try, see where it goes.
Well, excellent. And I know John Gwen is on our group here, and he used to handle a lot of those mediations, at least in my court. And somehow I think you'd like to volunteer to assist in this, right, John?
He was in our small group, Justice Gustafson. and so
Okay.
He's not getting out of this one.
So, we've had quite a bit of good discussion today. I guess I will ask Dr. Willcott, after listening to us and being here today, if she has anything, further wisdom she'd like to pass on to us before we ultimately adjourn for the day.
So there was one other thing someone asked in the chat about fostering connections, and I just wanted to just mention briefly the Fostering Connections to Success and Increasing Adoptions Act. And that includes things to improve outcomes for children and youth that are some of the things we're talking about. For instance, with relatives, notice to relatives while the children when the children enter care, the kinship navigator programs, which guarantees funds for those particular programs. Also subsidized guardianship payments for relatives, licensing standards for relatives. So all of those things are part of the Fostering Connections. And so certainly the goal is to improve those concurrent plans when they need to happen. With adoptive families, it has things like incentives for adoptions as well as adoption assistance. So I just wanted to mention that in response to chat. I appreciate so much the opportunity to be included in this. I learn as much from you all as I think I know, which I learn I don't know as I listen, and really appreciate the progress you all are making in your collaborative efforts. So thank you again for having me.
Thank you for being here. Julie, I just want to make sure from a housekeeping standpoint that I'm not anything I need to be doing before we adjourn, other than, of course, thanking Kevin Cook, who is our IT guy at Court Administration, for taking over this Zoom business. And so, and I see a few other things, but Julie, am I missing anything before we adjourn?
Just in case people didn't read, one last comment I put in the chat was for those of you who are attorneys and you want CLE credit, 3.25 credits have been approved, and you just need to email me your state bar number and the number of hours that you attended if you didn't attend the whole thing. And then next Wednesday on the 21st, I'll submit everybody's names and numbers to the CLE committee.
And as a final, we have some planning for as we move forward and moving the dial things. But as always, if there is some area of DN practice that you really would like to hear something about, we would really appreciate it if you would let us know, because we would like to address it. And if it's a lot of, if we're getting the same comments from everybody, we do have our planning for some future training and reasonable efforts and some of those type of things. And so always open to your suggestions. And also CIP is a great resource. Julie Burke, our contact person, if there's something that you are really wondering what's going on around the state or information that we could provide, I would encourage you to reach out to Julie so that we can get you the information you need. We will post again this session on our CIP website, and I want to thank everyone again for the commitment you have made to the child welfare work here in Montana. I know a lot of times it seems like we go 3 steps forward and 2 back, but I really do think we are making some huge gains in the work that we're doing across the state. So I really appreciate your willingness to put in the time and engage in this work. So thanks much. And I hope everybody has a great rest of their day and week.
Thank you.
Thank you. Thanks, everyone.
Thank you, Judge Willcott.